Okay, so we'll get past this in just a second here. This thing with Tom Cryer, for those who are expressing interest in that, Tom Cryer, the issue was about a fellow by the name of Clifford Kidd, who was facing a tax case, federal tax case in Austin, Texas. And I went there, and Clifford was convinced by a female to file some 1099 documents with IRS stuff against the judge. And I knew that it was going to be a problem, but he was convinced that, that she was on the right track, and he filed that stuff. And immediately they wanted to withdraw his bond and put him in jail, so that he would spend time in jail the whole time pre-trial. And they set a hearing for that. And I went. I was there with Clifford, see, and Tom Cryer was not. And Tom Cryer thinks that I created that problem when I did not, because I don't do that stuff. I know what it is. If this guy goes ahead and files that stuff against the judge is going to crack the whip on him. And that's exactly what happened. And Tom Cryer had even put it, if I recall correctly, two documents. And, one was mine, but the other one was not. And my document was simply my entry into the case so that I could help help Clifford Kidd. And anyway, my contention on that whole deal is that I did help Clifford Kidd because he didn't go to jail at that time. I told him that all he had to do was say to the judge, I made a mistake, I'm sorry I filed that stuff, and I withdraw it from the record. And it would be gone. And sure enough, that's what happened in the end at that hearing. But the judge was still upset and wanted him to have an attorney. Like I say, the problem documents were not, I didn't create them and had nothing to do with them. All I told him is that if you just withdraw those documents, you won't go to jail. And sure enough, when he withdrew that document, those IRS documents, he did not go to jail. But the judge told him that standard operating procedure told him that he needed an attorney, so he went back to Cryer. And the bottom line on that is, Clifford Kidd was convicted. Okay? Now, which Cryer lays out as a success. It's kind of funny to me. I think that success is when you're not convicted.
Maybe only did 2 years.
So he says that it was house arrest, but whatever kind of arrest you're under, it's not only that, but the conviction is a problem for anybody to get a felony conviction. Is there anyone here who doesn't understand what I'm talking about? When you get a felony conviction, you got a big problem. I know one woman that is like an angel, and she managed to get herself a conviction. They said that they were going to drop it down to a misdemeanor, but they left it on the record somehow as a felony. And she got herself a good job with the Target Distribution Center. And she started work there already, and then they said, no, you got a felony on your record, you're out of here. So she lost her job in a flash, just because of what was on her record, even though the woman herself is like an angel and wasn't guilty of the thing in the first place. But it's easy enough to get tagged with a felony, and the cops have these computers in their cruiser cars, and they get behind you at a red light, and just for fun, they run the plate and they see who you are. And then once they see that you got a felony on your record, and they'll shake you down, and they want to see if you got drugs, or you're drinking, or you this, or you that. It's the guys who got felonies on their records go through constant harassment with the police. It's just the way it is. So anyway, that's Cryer, and that's enough of that nonsense. One of the things I was going to share with you, trying to get off of this thing, but Barefoot Sanders, in that case with the State Department, and by the way, that case number is, for those who wanted to look it up, the case number for the case itself remains, that case remains in the law books. The citation in the United States Code Annotated, that's gone because Congress changed the law. But the case itself is U.S. versus Fox, 766 F Sup 569.
Say that again?
766 F Sup 569. Now, we're at a, now that I mentioned that, I'm going to share something else with you. Does everyone here know how to use the law library?
No.
Okay. Would you like to know in just like 2-3 minutes flat?
Yes.
Okay. It is so simple and so logical, it's just incredible.
You go through the front door.
Okay, my case is this citation, okay? 766 F Sup 569. Now, this is like a code, okay? And this number here is the volume of the book. This is, how should we say, the category, and this is the page. So you go into the law library and you say, where's the F Sup? You say, well, it's over there. And so you go to this gigantic rack of books and you look for book number 766, and it's right on the spine, 766. And these numbers go up to 999, and then they start over. Okay?
Then you go to soup line.
So 766 in the F Sup rack, and you get this book in your hands, you open it to page 569, and there it is. Now I have other stuff like, I should give you a real good one here. Now this one says U.S., and this means United States Supreme Court. Okay? If you go to this book, number 407, U.S., and look at page 25, you're going to see a case called Argersinger versus Hamlin. And so on and so forth.
Very
Now,
important case.
Yeah, Mr. Heitman knows that's an important case. And you can win, regardless of your circumstances in the court system, you can win with this one if you know what you're doing. I mentioned to you at the beginning that the good news is you can win on all these categories, and one of them I said is on the counsel issue alone. Didn't I say that? Okay. Well,
What case is that?
a winning on the counsel issue alone. This site is a case called Argersinger versus Hamlin, 407 U.S. 25. Okay?
Arthur what?
Argersinger, Argersinger versus Hamlin, Hamlin, I think it is. I will provide you the site on that stuff too. Okay? And so what that case says is no accused, that's y'all, no accused may be deprived of his liberty as the result of any criminal prosecution, whether felony or misdemeanor, in which he was denied assistance of counsel. And people will say, well, they brought me into court and right away they wanted to give me an attorney. Right? Well, what you need to do is thank him, but you need to interview the attorney for competence. Now, when you interview the attorney for competence, you're going to find that he's not competent. So it goes like this. When they bring you in and the judge says, well, I'm going to assign you this attorney here, blah, blah. Oh, thank you, Judge. Thank you so much. I was really worried, but you're helping me here, and I really appreciate it. However, I do need to interview this attorney to make sure he's competent. Now, on this topic, let's say this. I have a friend in Los Angeles named Ron, and he's currently facing a tax issue, and the court assigned him an attorney. And so Ron questioned his attorney as to his success, which is, of course, one of the questions you want to know. And the attorney's response was that 20 years ago, he helped one guy get a lesser sentence. Now, doesn't that really excite you if you're facing a serious prison time? 20 years ago, you helped one guy get a lesser sentence. I mean, is that a whiz bang or what? So if you ask, and I've got a set of questions, like 200 questions, and those of you who have emails and the rest of that, I can get that to you pretty quick and easy. And we need to probably make notes of this stuff too.
Pass around the list for email.
Well, you know what? We can do this.
Susie?
I think Susie has.
Susie's got it. Susie's got my email, right?
Okay. Because if I have your name, your phone number, your email, and your snail mail U.S. postal designation, I can keep in contact with you and send you stuff.
That'd be
Okay?
great.
Yeah, we need that.
All right. We're on the same team. Is that agreed?
Yeah.
Okay. So, I want to help you all as much as I can. I've got several sets of questions, but one is like 200 questions long. The bottom line is there's no attorney's going to pass muster on this stuff. So you come back in the courtroom and you say, Judge, I really thank you for having your kind consideration. However, this guy's incompetent. And the judge is going to say, well, we've got this other guy here. He's real good. He's real good. And you say, well, I'd like to, I need to interview him first because my life is at stake here. The judge says, okay, well, go use the jury room there and interview him. So you go off there and you interview the guy, and he's as goofy and as competent as the other one. They're all attorneys. And so then you come back and you say, well, Judge, I really appreciate your kind consideration, but this guy's incompetent. Well, it's possible it could go to 3 attorneys, but I've never seen that happen. Okay? Typically at the end of 2, it's finished. And by that I mean the judge is going to flip right out. And he's going to say, there's no attorney in the whole state that's going to satisfy you, so you're just going to have to represent yourself. And that's that. Okay? Now, when he does that, what happened? They lost the case.
Do you think
So-
judges know about this?
Okay? They know, but they think that you don't. So keep your mouth shut about it.
Well, don't talk too loud here.
Well, I get amazed that how stupid these guys can get, because I could show you this. I got this right here. This, you can't see it, of course, it's just printing here. But somebody might want to look at it. And what this is the Ferguson case, 2 pages, the first 2 pages. And I notified the judge in Tim and Dawn's case about this thing here. And when he went off on me, when I raised the issue of religious objection to the oath, I mean, I couldn't believe that the guy was so stupid, you know? But then this is a judge who right behind him has got a portrait of himself in the courtroom, a portrait of himself, 4 feet tall and 2.5 feet wide. The only people I know of that's got these gigantic portraits behind them are people who are really, really convinced that they are something out of this world. Adolf Hitler, Mussolini, Mao Zedong, Saddam Hussein,
Barack Obama.
you know. you get the picture. So, I mean, I couldn't believe the guy could be so dumb as to not know. I mean, this is from the Fifth Circuit. This is his bosses. He didn't read their thing. He didn't read my stuff in the civil case that I warned him about this. And the whole thing's blowing up in his face because he denied me, my right to testify and Tim's right to have me as a witness. The guy's an idiot. Well, and especially the fact that they don't understand what religious freedom means. See, I mentioned it to you right at the beginning that there are some powerful tools and religious freedom is one of them. You know, and I've got a list here that I just threw together in the jail cell. Okay? Now, one of the things was, I went to Dallas County Jail, and they served breakfast, and I didn't touch the tray. And the guard came to come to pick up the empty trays, and he sees that I haven't touched the food. He says, "What's the problem?" And then I said, "Well, I don't eat pork because it's against the Levitical food laws." And he said, "Well, that's not pork." I said, "Well, what is it?" He said, "That's ground turkey." I said, "Are you sure?" He said, "Absolutely." He said, "The Muslims have sued us so much that there is no pork in the kitchen whatsoever. None."
Only pigs. Only pigs.
Huh?
Only pigs.
So, this one guy, Jeff Skiba, I'd already had this experience on the oath issue in the Skiba case. I'll come back to that. But because we're talking about the religious freedom, I'm just going to give you a couple other points here. And one of the real whoppers is this one here, Gonzalez v. O Centro Espirita Beneficient Unia do Vegetal. And anyway, what this is a case. U.S. Customs had some 5 barrels, and I guess these are like 55-gallon drums, on the dock. I think it was probably Los Angeles or something. These barrels had come, barrels of tea from Brazil, destined for a Brazilian Indian tribe church in Arizona. So maybe you all have heard of it. So one of these customs officials takes it upon himself to check what this tea is. And it's like the powder stuff, like you got in a tea bag or something. But this is no ordinary tea. They check and they find it's Schedule 1. Now, do you know what Schedule 1 is? Stuff like heroin, cocaine, methamphetamines, those are Schedule 1. Okay? So 5 barrels of this stuff, and they go bonkers because they check and they find out that there's been 15 previous shipments. You know? And so that brings the Department of Justice attack on this church in Arizona. And the whole works goes all the way up to the Supreme Court of the United States. And the Supreme Court said to the Department of Justice, there was a time when something could be done about this. However, now that Congress has passed the Religious Freedom Restoration Act, you can forget it. Give them their tea back.
That's a happy church.
Well, I heard this last item here, something that's interesting. And I cite this in all of my stuff in this first paragraph on an affidavit. And what it is Federal Public Law 97-280, 96-1211. You don't need to worry about writing it down because I'm going to provide you with the affidavit and you'll see it in there, in the first paragraph. Now, what that law is it's something special. And what's special about it is this, that this law is the only law that has ever passed through Congress unanimously. Even the declaration of war against Japan after Pearl Harbor did not pass unanimously. This is the only one that ever did. And what this law says is that the Bible is the Word of God, and that we should apply its teachings in our lives. It goes on to say a bunch of other stuff, but that's the serious part. It's the only law that ever passed through Congress unanimously. Declares that the Bible is the Word of God, and we should apply its teachings in our lives. And I use that continually. Why do you think that I'm still here? Immigration would have deported me. You know what I mean? And so,
King James Version.
huh?
You should say the King James Version.
Well, I understand that that's commonly accepted, and I got the King James Version right here. But there are some others that are very good too.
No, they all misrepresent the truth.
Don't argue with him.
These are needs.
Well, you can use the right cover. What's inside doesn't matter, right?
You got the right Bible.
You know what it is telling you this. He tells you the message with stammering lips, etc. And what it is that you have to pray for wisdom when you read that book because the stuff is hidden from you. I'll give you for instance. I don't know how many people here understand that, like, number one, the Bible doesn't waste words. And it says that David selected 5 smooth stones from the brook. Now, why was it 5 instead of 3 or 15?
Why?
Goliath had 4 brothers. They're named elsewhere in the scriptures. So if you think about that one for a second, from David's perspective, like a chess player, from his perspective, he's going up against Goliath. Goliath has 4 brothers, and when he kills Goliath, the 4 brothers are going to be on him. So how many stones is it going to take with our Heavenly Father guiding his aim? 5. 1 for Goliath and 4 for the brothers. Not 6, not 7. No misses.
You're right, but that's all you could count.
That's all he counted. He forgot about his other hand. Okay, so, all right. This thing here, by the way, all of these different categories, there'll be like, there'll be this one here, there's F, F2D, F3D. If you can imagine this, you go to this law library, And this F sub stands for the federal trial court. Their appellate court is just F, okay? But this is the first series. Then it goes to the second series, F2D. Then it goes to the third series, F3D. Like I mentioned, the spine of the book goes from 1 to 999. Basically 1,000 books in each set. So in this stuff, you're looking at, they're working on their third 1,000. And so there's a lot of stuff there. But this kind of an arrangement where this is the volume, this is the set of books, and this is the page number, you can find anything in a flash in that law library. And so you don't need to be scared of it at all. How's that for a quick, short law library visit? Okay, so on the council issue again, that Argersinger versus Hamlin, if you get them on that, they're toast. They did this, I'll explain this case to you, and this is kind of interesting. I think anyway, you tell me if you don't think so. So there's this guy, Don McCarley, this is a true story. So Don McCarley is a trucker, and he stops to use the phone at his brother's office, a high-rise office tower on the North Dallas Loop. Okay? So he's there on the phone, and that day, surprise, surprise, 9 IRS agents arrive with their badges and guns, and it's search and seizure time, folks. And they come up to him, and they grab the phone from him and slam it down, and they say, "Who are you?" And he says, "Am I under arrest?" And they said, "No." He said, "Well, fabulous. Adios, I'm out of here." And he gets up and he goes out to the hallway, and he's going down the hall, and suddenly he remembers he forgot his car keys on the desk. He half turns around, they tackle him to the floor, beat him up, handcuff him, and haul him off to jail. And charge him with 2 charges. One is assaulting federal officers, and the other one is impairing a search and seizure. Well, he doesn't have the money for an attorney. And I'm not an attorney, but, sometimes I do some typing. So what happens is, I typed the thing up, and it says, these IRS agents that say that they were assaulted. And by the way, you have to get how preposterous this is. Because meek, mild, polite Don McCarley, who is so nice to everybody, unarmed, is going to attack 9 armed IRS agents. How ridiculous can you get? It's so preposterous that, any logical person is going to say, that's ridiculous. But it gets better, because I put in the document, I said, okay, these IRS agents claim that Don McCarley assaulted federal officers, and they're the federal officers that he assaulted. Only problem is, IRS agents are not a part of the government, therefore they're not federal officers, and their claim that they are is a 10-year felony.
Oh, wow.
And that charge disappeared from the planet. There was no discussion, there wasn't a hearing, there was no talking about it, there was no paperwork, there was no response. That charge was disappeared from the planet, and that was the end of that charge. Gone. Now, Don McCarley comes into court, and federal judge Jerry Buckmeyer is there, and Jerry Buckmeyer knows me because he's the guy who signed the order to send me to Springfield on the oath issue. And while I was at Springfield getting my head examined, while I was there getting my head examined about the oath issue, the Fifth Circuit Court of Appeals, his bosses, ruled in my favor in the Betty Ann Ferguson case. You know, and anyway, Jerry Buckmeyer's there. Don McCarley, he informs Jerry Buckmeyer that he wants Robert Fox as his assistant of counsel. And Jerry Buckmeyer says, no, Mr. Fox is not a licensed attorney in the state of Texas, and the answer to that is no, and no is no, and that's it, there's no way. Okay? So, what did he do? He denied Don McCarley assistance of counsel. And he wanted to force him to go to trial on his own 2 feet, and that's what happened. Don McCarley went to trial on his own 2 feet, doing the best he could, and he didn't have assistance of counsel. Jerry Buckmeyer denied that. And so these IRS agents, they said that Don McCarley beat him up. They didn't claim to be federal officers anymore, though. They just said that Don McCarley beat them up and damaged their wristwatch and bent their eyeglasses. Oh, it was just terrible. So they went on to say that the way he impaired the search and seizure, which was another puzzling thing, because how does Don McCarley impair the search and seizure when he's in the hallway and the search and seizure's in the office? Well, you're going to love this one. So they talked about it, and it was the prosecutor that really helped the jury to understand how Don McCarley impaired the search and seizure. Now, the way the trial goes, by the way, for those who don't know, the newbies, the government goes first, they present their witnesses and evidence. You got the prima facie break, then the defense presents their witnesses and evidence. Then it goes to closing arguments. The government goes first, then the defendant goes next, and the government gets another shot at it with no possibility of rebuttal from the defense. Okay? It's a setup, you know, so that the government gets the last word. They get the first word, they get the last word. That's why their win ratio nationwide is less than 2% for our side. You know, when the cops say you did something, you're almost a goner right there, unless you study alternative stuff like this. You know, and what I'm describing to you in this counsel issue is one that you could potentially win with even if you were guilty 10 times over. So they said, the prosecutor says, well, the way he impaired the search and seizure was that it took 3 officers to take him to jail, and they came with 9, and they only had 6 left to do the work. Now, I wrote up the thing for his allocution and pointed out that following that logic, they could have stopped at the Galleria Mall, selected 3 random shoppers, put 3 officers on each one, taken them to jail, and boy, the search and seizure would have been really impaired because there would have been nobody to do it. You can't tell us what happened after you put the handcuffs on him. You got to tell us what happened before you put the handcuffs on him. Right? And was he impairing the search and seizure before the handcuffs? No, he was in the hallway. So anyway, Don McCarley comes in for sentencing because the jury convicted him. They listened to this crap and went ahead and convicted the poor guy. And so, you know, I mean, he was devastated. And I said, well, it's not over yet because you got sentencing, and at sentencing, the judge has to ask a question. And the answer, if you know what to give the right answer, you walk out the front door. I'm not kidding. I'm not kidding. There's a do you remember Robert Bork?
Yeah.
Okay, he was Solicitor General for the United States. If somebody sued the United States, that lawsuit landed on his desk. So, he was Solicitor General for the United States. They were considering him for Supreme Court Justice. He didn't make it, but he wrote a book called The Tempting of America. In the first edition only, because after that it's deleted, he made the statement that everyone who is in prison in America today is there voluntarily. Voluntarily. And the place where you volunteer in their criminal process is at sentencing. And the rule on that is the Federal Rule 32, which is to do with sentencing. And there's a whole bunch of stuff in that rule, but there's a paragraph in there that says the court shall, and shall means must, the court shall address the defendant personally. You may have an attorney, you may have like the dream team, like OJ, but that doesn't count. The judge addresses the defendant personally, eyeball to eyeball with the defendant, and the court is required by the rule to inquire whether the defendant has a statement to make or any information in mitigation of sentence. Well, now isn't that interesting? Let me ask you, since they've already got the jury conviction or bench trial judge conviction, they've got the cells waiting, they've got all the guns, they got immense manpower, and they have to ask a question. The reason they have to ask a question is because it's your turn to volunteer. So if you give them the wrong answer, you go to prison. And in Don McCarley's case, we've done it up in writing with an allocution affidavit. And that is helpful, but it's not the be-all and end-all. The real stuff, the real deal is what you speak in the courtroom. Like I mentioned, affidavits are hearsay until they're testified to. So when Don McCarley speaks it, that's what really does it, as testimony. So Don McCarley's allocution, the number one was the fact that he'd been denied assistance of counsel. He requested me, was denied, and the United States Supreme Court said that they can't incarcerate him on that basis. How do you like that? Then the other parts went on, like how do they possibly claim that Don McCarley assaulted or impaired the search and seizure, because the assault thing was gone. How he impaired the search and seizure on the basis of them talking about what happened after they put the handcuffs on. And there was a whole bunch more stuff in there, and that the judge isn't an Article 3 judge, and that the court isn't right, and so on and so forth. And so anyway, the Argersinger versus Hamlin and the other stuff carried the day, and Don McCarley walked right out the front door of the federal courthouse in Dallas, had his sentencing. Now, before that happened, of course, he's in court, and he'll get a kick out of this, I think. Knowing what they're like, I did up a script for Don just in case the assistant U.S. attorney tried to speak at his allocution. And sure enough, that's what happened. Don McCarley started up, and immediately the assistant U.S. attorney jumps up to object. So So Don McCarley turns on him and says, "This is my allocution, and I deny that any pettifogger, shyster, groveling for filthy lucre has the status, standing, and authority to speak at my allocution." And that guy went beet red, sat down, had not another word to say, and there wasn't a peep out of the federal judge.
Say that again.
Can you repeat the question?
Are you serious?
Yeah, I need to hear.
You're putting me on.
Hey,
Okay, you want to hear it again? Serious?
yeah.
Okay, Don McCarley said to him, when he jumped up to make an objection, Don McCarley said, "This is my allocution, and I deny that any pettifogger, shyster, groveling for filthy lucre has the status, standing, and authority to speak at my allocution." The allocution is the judge asks him a question, and he makes the answer. The prosecution's got no space in there, you get it? No space, they got no room to talk.
The
It's
objection.
between him and the judge.
Can you just say shut up?
Sounds good. That sounds
But it's not as good as what I put together, is it?
You need to have a mouth full of words on that one. Juicy. Juicy.
So, goes to show you can still have some fun. And, but they didn't think it was fun for the Systemites. And Jerry Buckmeyer actually tried hard to get Don McCarley just to shut up and go away, you know. But Don McCarley had to get the stuff off his chest because he was really upset about the whole situation. And so he laid it on him thick and heavy and walked out the front door.
And what do? They just let him walk out? I mean,
Yeah.
That's it? After he speaks, he says, "You're free to go."
The judge let him go.
Didn't volunteer.
Didn't volunteer. Exactly. And so if you're ever faced with that situation, and we'll go over it tomorrow, we'll go over, you know, the steps in the process. You get to that position, do not volunteer or consent to any of it. You know, because they're going to say, well, we want to, you know, sentence you to such and such. Say, well, excuse me, what's the sentence for someone who's innocent? Well, you're not innocent, you were found guilty. No, you guys framed me with your nonsense. You denied me my witness, you know, like Tim and Don. You know, the judge denied me when they asked me to be their witness. I was flanked by 5 U.S. Marshals and basically booted out. Okay? That's against the law. You know, how this judge ever thought he could get away with that nonsense is beyond me, but, you know, he's an idiot. You know, he's so infatuated with his big portrait behind him. You know,
He's watching himself.
yeah, he's so busy with watching himself that, you know, that he doesn't have time to read my documents. Otherwise, he would have known that he was being forewarned as to the possibilities.
But they do break the law and they get away with it. And the reason they get away with it is because we don't know what to do. Am I correct?
Yep. Yep. And this gentleman brought up about, he said, we don't know what to do. And he said that earlier that in private that he'd done some affidavits and that nothing happened. And of course, I don't know exactly how or why in your particular case. Affidavits work for me, and if they don't work for people, I'm not exactly sure why, but you can run into bozo idiots like this judge in Tim and Don's case, or Jerry Buckmeyer, who just openly told Don McCarley that he couldn't have me as assistance of counsel. You know, and of course since then, you know, I mean, I've sat at the defense table in 5 different states in federal court. In Texas, by the way, the judge had 3 of us, not just me, but Richard Taylor and another guy, but if the name's on the tip of my tongue, it'll come to me. But, and because he's a real good guy too. So there were 3 of us at the defense table helping Kenny O'Kane. And unfortunately, Kenny had left the whole thing to the last minute, working around the clock. And he was so exhausted he couldn't function. I prepared a set of questions for him, he couldn't even read them.
Excuse me, did you say you were gonna provide us with a copy of the affidavit?
Yes,
Okay.
yes,
With that statement?
you're right.
I can tell you why that is.
Pardon me?
I can tell you why that is.
Okay.
You want-
Yeah, we can speak. Microphone.
Yeah, but keep it short.
I was at a hearing, and I had 3 witnesses sitting back here.
Take your hand off the mic.
3 witnesses sitting back here. They were gonna testify the affidavits they put in. This judge says to me, I ought to known better, but I didn't. I thought I'd cite it. So I figured I was gonna win this case no matter what. Well, he says, Mr. Byron, well, he says, this is gonna take a long time. He says, why don't we just agree? And I'm sure Mr. Erickson, the other attorney, will agree that we'll just put them on the record and they will be as if they were testified to, ready in the record. And it's going to save us a whole lot of time because we'll be here most of the day if we don't do that. And he says, won't you agree, Mr. Erickson? Yeah, I agree. I guess he would. And as soon as I said, yeah, I tried. You know why?
Because they wouldn't testify
One of
to-
those testimony, one of those affidavits had, you have 30 days or so many days in which to answer or deny this. And if they didn't do that, then they must testify to the affidavit or the affidavit's worthless. And I walked out there, this same judge took the files to his office, 130 miles away to Pocatello Island, and kept them 6 weeks. And a lot of the stuff that was on the record is not there anymore. So what I'm telling you is the affidavit has to be testified to unless it has the language in it that he put in there. Otherwise, you're fried. There was one other thing that you mentioned there just a minute ago. I forgot what it is. That's the most important thing I had to say about it. There was something else that was in my mind. I can't remember what it was because I'm overage.
So the affidavits that I'm doing, like he was saying, it's taken some time to put that stuff together, and I haven't had anybody challenge me on that stuff. And, to me it means that it's working. If you're going to use something, you're welcome to copy it. You have your own case and the particularities of your own case. But the framework of the affidavit with this paragraph and the way it ends, those 2 pieces are, to my way of thinking, they're a proven element from this. But if you deviate outside that, it's at your own peril. I've had people that would delete that whole last paragraph. Now, I don't think that's a smart thing to do because you could easily fall into a trap with them and they could say you made a falsification here and they put you in prison.
The other thing I had in my mind was this business of allocution. There's a case, I can't remember the name of the case, but I think you can find it if you search it right. It was a Florida case, and this old black woman had a son that used to deal in junk. And he walked home and they searched the house, and they found narcotics, and they charged her with it. And she didn't know what she was going to do because she wasn't ever involved in the narcotics. You know, she was a kid, but she didn't know what to do. So it came up to allocution. I read this case myself, and I forgot the name. I read this case, and it's a Florida case. And she went to sleep there, went to bed that night, and she all of a sudden woke up in the middle of the night and she had this dream: I'm not going to take that sentence. So she goes to court the next day and they go through a whole business. Well, Mrs. Smith, whatever her name is, I'm going to give you 25 years in prison. Do you understand me? She says, no, I don't understand. I'm not taking that sentence. Oh, we got to have a sidebar, so they go up there and have a little talk. And they come back, and the attorney walks over. Would you take 12 years? And she says, no, I'm not taking no sentence. I am not taking this. I'm not going to jail for something I didn't do. I'm not accepting that sentence. When you say you're not accepting that sentence, they've got to pound you in the head with a club until you do accept it. And she kept that up, and they went down, well, would you go for 6 months? Until it's the end. And she says, I am not accepting no prison sentence, but I am not a criminal. I'm not taking that sentence. Guess what? She walked out the front door. And I don't know why I can't remember, but I got a lot of other things on my mind too. So that verifies what he said. And I remember that case very, very well because I used it myself. The same thing in a case last January. They found a decision. And it was just a railroad job. The attorney and the judge and myself, and the attorney testified. The attorney cannot testify for summary judgment, period, because it has to be a live client. And I said, I'm not taking that sentence. I object, and I've done so within 3 days. I'm denying you some lost fair trade warranty. It's a contract they're offering you, and all you have to do is accept the contract.
Or not.
Yeah. That's the key point, is you do not accept anything that they have, and that's the end of it. And the whole system is voluntary, and it's not because I say so. I mean, Robert Bork even put it in his book. And on the council issue, I thought of another one I should probably share with you. So I mentioned earlier, some buzzing here.
Rewinding the tape.
Yes, we rewind your tape.
Oh, okay. So I mentioned earlier John McGladdery. He had a friend, a lady by the name of Isabel Suarez, and her husband had been in a train wreck and damaged his head. So he was just good for like sweeping the floor in the warehouse. And they had a son, and Isabella was the breadwinner for the family. And she got accused of a felony in Chicago, and they had her in the news and the front page of the newspaper and all. She did like everyone does. She went ahead and hired herself a good attorney. And she took a whole box of evidence that proved that she was innocent. And this guy didn't look at any of it. And he postponed the case. It's called continuances. One continuance after another for a year. Getting close to trial, she took him a list of the witnesses to be subpoenaed because these witnesses could prove that she's innocent. He subpoenaed none of them. So, just days before the trial, he tells her that she needs to wrap up her stuff because come Monday she's going to trial and she's going to prison. Oh, isn't that a great defense strategy? After she paid him, thousands of dollars, That's the defense strategy.
I just had a quick question. Concerning the allocution, if there's, say, the most perfect scenario where there was eyewitnesses to someone that murdered another person, would that allocution strategy still work? I mean, is it 100% completely voluntary? If there's
Well, it's,
No.
pardon me?
Because if it was a murder case, it's an offense, not a crime. It won't work in an offense. An offense is something against a human body. If you damage another human, it's in the Bible. You won't get off ever.
Okay.
There's no way. That's one of the reasons why you'll find in all of these processes, like the thing Gordon Hall does and this, et cetera, they won't work because those people that are in prison that have done those heinous things know they're wrong.
Is Gordon Hall here?
He left early this morning.
He was here this morning?
Yes.
He's with his friends.
It's on top.
We're talking about.
Flip the switch.
We're gonna switch on to.
Hope I'm okay coming up here. We were talking about that because what happens if somebody killed your child? And the court system, that's the only justice system we have on the face of this earth right now. And just because some guy comes up here and says, I'm not going to prison, what then? I mean, as a parent, what does a parent do? Or a wife or whoever?
Carla, it would go back to something like I was trying to share with you all this morning. And that is that when I would try and help somebody and they could fool me, I'm gullible that way, I'm soft, okay? I know it made me look like I'm rough and tumble, but, I'm like a marshmallow. So anyway, and I used this line on an airline stewardess, not this last trip, but, I said to the airline stewardess, I said, landings are very, very scary. And I said, I'd feel a whole lot better if you'd sit and hold my hand. She says to me, nice try, but you don't look like anybody would be scared of anything.
That's right.
Anyway, I get tricked sometimes, and I do work for people that are actually guilty. But what happens is, they freeze up, they can't do it. And even if they could, Carla, something else will happen. I didn't mention this before, but two of the police that arrested me, I've been arrested over 30 times, but these two guys were together on one arrest. Both of them lost their jobs. Two other cops on separate arrests both died, and they died young. One of them was turned to mush on the 635 loop around Dallas while he was trying to issue a ticket to somebody else. Two judges were unelected. District Attorney Ray Summerall from Rockwall County, who framed me and put me in jail for half a year on bogus charges. And later I made myself dinner, I sit down, and I turn on the TV to catch the news. And surprise, surprise, Ray Summerall, flanked by two deputy sheriffs, coming out of the courtroom, sentenced to prison. Why? Because he tampered with evidence, coerced his employees to perjure themselves, falsified records, embezzled from the state, all of that. He ended up with 15 years in prison. Yeah, he put me away, but it got up to him. So, it's with all of this stuff, it's more in the hands of our Heavenly Father than it's ever in our hands. And you can have crooked judges, and the guy could bribe the judge, and all of that. But when he gets out from that, there's no telling what's going to happen to him. You know, he's going to meet up with half a dozen muggers in the back alley that are going to leave him looking like hamburger.
Yeah, I've been told that it's even a volunteer to take your fingerprints, so you don't have to give them your hand. Same thing with the TSA. Do you go through do you volunteer to be searched?
Well, I know that they don't have the authority for a lot of this stuff, and with regards to the fingerprints, I completely agree. And I posed the question at the Dallas County Sheriff's Department. I said, what statute is it that you rely on for summary brutality in lieu of the normal fines and imprisonment? Choke and puke question. You think about it. What statute is it that you rely upon for summary brutality in lieu of the normal fines and imprisonment? When I say I'm not going to give my fingerprints at the Dallas County Jail, instantaneously you got half a dozen guys on you. They will slam you to the floor, and a guy as big as a double refrigerator puts his knee on my neck. My face is mashed into the concrete. I'm passing out, black clouds going through my head. I got my arms twisted up behind my back, all of that. Okay? And that came when they did something like this to me, when they tried to get me for unauthorized practice of law. And amazingly enough, they basically tortured me and everything else. Now, here comes the funny part. Comes time when that you get out, okay? And this deal was only 3 days long, but it was bad. So on the third day, I'm getting out. And this guy is standing beside me, a black fellow, young guy. He says, this is really funny. He says, you being here. And I said, what do you mean? And he said, well, we were together when you booked in. And he said, this is the first time I've ever booked out with the same guy I booked in. And I said, oh, so you saw what they did to me? And he said, yeah, I sure did. And I said, would you be willing to execute an affidavit, sign an affidavit to that effect? And he said, no problem. and they were like in a state of shock when they brought me back into, not brought me back, but that just put the kibosh on their whole deal when they started filing an affidavit raising the issue of torture. Okay? And there was another funny too, if you want to hear it. The guy who was representing the Committee on Unauthorized Practice of Law, he had brought this process against me, and they arrested me at the post office and put me in the Dallas County Jail and brought me in the next morning to court. And this attorney goes to the witness stand and testifies. And he says, I mailed this stuff to Mr. Fox, certified mail, and I have the envelope here. It was a 9 by 12 manila envelope. And he says, this came back, and I have it here, intact, and that I hadn't shown up at the court proceeding. And so the judge says, well, let me see that. So the attorney hands it up to the judge. The judge looks at this manila envelope, looks at both sides, it's still sealed. Pulls out his letter opener or scissors, I forget which. Anyway, he opens the end and pulls the document out. and he reads the document page by page, and then he says to the attorney, I don't see anywhere in here where you mention the date and time of the hearing. And the attorney says, I sent that a separate, first-class mail. And the next question was, do you have any proof of service? And there was this stone silence for a moment or two, and then he says, and it went like a resounding thing through the courtroom, no. And their whole case collapses. You know?
I have another one. You want to hear that one? It's a known fact that a judge sits with a sword of Damocles hanging over his head with a fine silver thread. And he doesn't want to cut that thread. That's a fact. If you look at the trial of the football player, O.J. Simpson. O.J. Simpson sat in jail for a long, long time. And there's a Shakespearean play called King Henry V. It's very short, but there's a soliloquy in that. It's tremendously long. And one man at the time had to memorize this and say it. And it was quite a feat to do that. And in the middle of that, he says, the troops came into the town and they apparently butchered, beat the town up pretty bad. So the way I would say it right now, he said, they may defile virgins and they may, can't think of the exact quotation, but in the end of it, it says, they do all of these things, you know, and he lists them. He says, but they have no wings to fly from God. And that was in 1600, okay? 1624, Shakespeare now. I've got a thing here that you might want to share with these people. I gave it to Susan, that I carry around with me just in case I get hit. And it says Federal Court Defense for Tax Cases. This is for, you want to read it? And then I can do for him.
Well, how long is it?
Just 1 or 2 lines.
Of federal tax defense?
Yeah. Yeah, it's for willful failure to file. And what I'll read it. It says, Your Honor, I'm not aware of any statute that makes me liable for the tax. Not the tax that places a duty on me. I can't read well, I'm going blind my left eye. I see 2 words at the same time. And that requires me to file a 1040 form, individual form, or any other income tax return. What this does for you is 2 things. It asks the prosecutor, he has to ask the prosecutor to inform the jury. And the prosecutor can't do that because it's a general statement and it doesn't make you or me or anybody else in here liable. And they're charging you, not the world. So generally they dismiss the case. But if nothing less, it maintains your innocence and presumption of guilt. If nothing else, anybody wants to have a copy, we can have it.
Thank you. So, I just started to explain this thing with Isabella Suarez, and that situation there, when when she was facing trial and the attorney wasn't doing anything for her, told her to wrap up her affairs because she was going to prison on Monday, she was just going bonkers. And she told John McGladdery what the situation was, and he said, you need to get Robert Fox here immediately. So she, covered the airfare and home, had me come to Chicago. And I arrived Saturday night, and trial was going to start on Monday. I left basically one day, Sunday, to get ready. And so I explained first off to Isabella Suarez that she could still do okay and that she was not going to go to trial on Monday if she could keep it straight on just one liner. I said, all you have to do is keep straight one line and you will not go to prison on Monday. And so that got her attention. And I said, first off, what we got to do is get rid of the attorney. And I said, I got the paperwork for that, okay, blah, blah. And then I said, the judge is going to be put in a position where they're going to have a real problem, and he's going to try and make you move forward pro se. And he's going to say stuff like, you're going to have to represent yourself pro se. So you hear any of those words, whether it's pro se or represent yourself, so you hear any of that, you have to, your response is, I'm not here pro se, I'm not representing myself, I am myself. And the trick to that deal is this: if you got a coupon for a cup of coffee, can you drink the coupon? No. It represents a cup of coffee. If you eat the menu, your tummy will not be satisfied. It's merely the representation. What you want is the real, steak and eggs. Now, so we go there on the Monday morning, and she immediately files to terminate the attorney. And it was a heck of an experience, actually, because it was the first time I ever saw anything like this, and I never ever since. In Chicago, they had, how there's two parts. You got the audience area and the action area in that courtroom. And you got the communion rail. That's in most courtrooms. But there in Chicago, it was bulletproof glass, floor to ceiling. And you've been there? No? Okay, well, that's what it was. It was bulletproof glass, floor to ceiling. The audience got sound via speakers. The judge had the switch at the altar. If he didn't want you to hear, he just switched it off. And you're watching a silent movie in a glass box. I mean, it was unbelievable, but that's the way it was. And I assured Isabella Suarez that I would be with her if I could. I said, but there's no telling what kind of reaction the judge is going to have. So we get up there, and by the way, I've been with a lot of people and had success, but in this particular situation, she and I go up there. The judge takes one look at me and he says, "Are you an attorney?" And I said, "No." And the bailiff was already coming towards me. And the judge says, "Well, you get back in the audience area." And he had that kind of tonality that it's like, you're going to be back in the audience area or the bailiff's going to put a few lumps in your head. And, I could tell that there was not going to be any progress in this outfit at that time. But I had already instructed Isabella Suarez in this matter. And I also told her, last one who speaks wins. And I said, this guy's going to try several times. So she's up in front of the altar, face to face with the judge. She's having a knee-knocking experience. Her whole family's at stake. And the judge says, "Well, I see that you fired your attorney, and we have a jury pool of 50 jurors here, and there's been too many continuances already, and there's not going to be another continuance, and that's that. And since you fired your attorney, you're just going to have to represent yourself pro se, and that's it." And she says, "No, I'm not here pro se. I'm not representing myself. I am myself." He was like flabbergasted, you know. And he tried again and again and again. And to her credit, she, every time, just like I told her, anytime you hear those words, "No, you know, I'm not here pro se. I'm not representing myself. I am myself." And this happened like about half a dozen times. And suddenly, something different happened. Suddenly the judge, from his like mean, ferocious, tyrannical character, all of a sudden he becomes like Grandpa at the fireplace at Christmas time with his favorite granddaughter on his knee. And he says, "Zoila," no, it wasn't Isabel Suarez, it was Zoila. Yeah, that's the correct name. Zoila. He says, "Zoila," he says, "here in Chicago, we have these incredible skyscrapers. And at the top of these skyscrapers are the finest attorneys in the world. So, Zoila, if you would just pick one, any one, the most expensive one you could find. Here's my business card. Call me. And when you pick the attorney, just call me and I will call that attorney and explain to him that it's his turn to do pro bono work for you, Zoila. And that means that you will not have to pay anything. And you'll have the best attorney in the world." And, you know, so she takes the business card and we went to lunch. and later, she prevailed. Because there are some attorneys that are like $10,000 an hour. And they're not in the business for losing. You know, they couldn't stand it on their record. So, let's see. So
6 minutes.
6 minutes.
Take some questions?
Okay.
You mentioned that you put in an affidavit on the issue of torture, and I wanted to know after that, like, how do you stand on those documents, and what are you telling them to do to make amends for that?
Okay. I was in open court, and I didn't know then what I know now. And so I raised the issue, and the judge was telling me that they had immunity. And that because of their immunity, they were dismissing my action against these attorneys for what they had done to me in Dallas County Jail and so on. And so he was dismissing it. But I could tell by the look on his face that they were really, really concerned. And so I didn't get where I needed to get on that case because their claim of immunity. But now I know there is no such thing as immunity for a criminal act. And And I was just overwhelmed at that particular time, you know, because I was up against a whole battery of attorneys, and the judge was already ruling in their favor, which never should have happened. And I knew it wasn't right, but I didn't have my ducks in a row at the time to really fight him on that. And it still exists as a possibility. I also had some experiences too, like I had mentioned the thing with the State Department. I beat the State Department, and people asked me, well, did you sue them? Yes, I did. Some interesting things happened. The guy from the State Department that swore out the criminal complaint against me, they transferred him to Vienna, Austria. Gone, like that. The prosecutor, the female prosecutor that Mike Wilson trained, she disappeared, gone for years. And as far as me suing them, I was rearrested, and they put me through such a savage beating that they broke my back. One of the guys that had beaten me up the first time at the Dallas County Jail, he came and stood over me on the floor with a broken back. And this guy comes and stands over me and says, "So, Mr. Fox, are you going to appeal now?" You know, they do that kind of stuff. But I don't give up. And so, you know, I'm still working on suing these jerks.
Since we only have 3 minutes, I only have 16 questions. I waited patiently now, okay? I got
That counts a
questions
lot.
in a row. Yeah, right. So do we go through this today, or whichever one you choose to answer? We went over the mental evaluation, but there was no comment whether or not you can have your mental evaluation before you go to court, and there's like a statute of limitations. In other words, you get a mental evaluation in the last 3 months or 6 months, then you get to pull a new one. Is there such a term?
Well, I think that if it was a long time, you know, they might be able to raise that as an issue, but, you know, if you know that something may come down,
Yes or no, please.
when they do that to you in court, the answer is, I swore an oath to tell the whole truth, and if yes or no does not cover it, then I need an exemption or an immunity from perjury.
Nor am I an adversarial witness. Therefore, they can't pull that either. Anyhow, next one. Can you comment on why the attorneys don't have a license?
Why would they have a license?
I'm asking, can you comment on that? Elaborate a little bit.
Okay, because they're running their racket, okay? And they're not about to set themselves up to have to pay any of us, like the riffraff. You know, they consider us down here, and they're an exalted status as an attorney.
So basically, all
You
they
know-
have is a bar card?
All they got is the bar card. The bar card. I mean, if you get stopped on the freeway by a state trooper and he says, "Let me see your driver's license," and you give him your American Automobile Association membership, what's he going to say? This is not a license and this is not good enough. They have a bar card. All that is a professional association, and it's not a license. And if you get into a discussion with them, the question is, what state officer accepts the annual renewal fee, and how much is it? And you have a receipt. They paid nothing. They paid for the bar, but the bar isn't the state.
And it's not a
So
license.
who's issuing this license?
It's not under the Business Bureau.
Huh?
It's not under the Business Bureau.
Right.
Right. Once we pull his rocks out, fire. No, my friend. Okay, Can we get a copy of the document for entry into the case? Thank you. You mentioned Mr. Lattery, John Lattery. Is that case published?
Pardon me? No,
No.
not that I know of.
We wouldn't be able to have access to it, or is there any way that we can know?
It was in a suburb of Chicago. I think it started with a W, but I can't recall exactly. I'm not sure. I'm not sure.
Okay.
That sounds more like it. I'm not sure though.
Was it up north towards the, right off the lake?
I don't recall.
Okay. Well, if we do, maybe we'll talk about it by tomorrow. Going back to the mental evaluation, this thought was an afterthought, so why do you believe that the fifth, raising the fifth, the mental evaluation might be able to stop them on the spot?
Because you cannot be compelled to be a witness against yourself. It's like the Miranda warning. Okay? You have a right to remain silent.
Okay.
Okay?
So wouldn't that imply that even upon the proposition of undergoing such a mental evaluation, you can at that time decline or not volunteer?
Right. Right.
But they force it upon you.
See, okay, the difference between the two things, if you've got a mental evaluation that you could whip out in court and say, I've already got my mental evaluation, that stops them dead in their tracks. Okay, which means that you're going to go home to lunch with your wife.
Sure, it's understood.
Okay.
I'm talking about
But-
if they pull you off the road and then you end up with this, you get steamrolled and you don't have time to do this. I mean, none of us here expect to have a mental evaluation, right? I'm not just going to go carry one in my pocket for the next couple of years, just in case. So,
Okay, all right.
I'm just
I
saying.
understand what you're saying.
Right.
Now, if you do get caught, like, they're not going to send you to a mental evaluation or a parking ticket, leastwise not that I've ever seen.
Oh, you want that?
But you get, but you get into a ruckus with a federal judge about tax evasion, you'll be in a mental evaluation in a flash.
Well, times are tough right now. Nobody makes a buck. Anyway,
But you know what I'm saying? Even if you use this strategy, yes, it'll save you from the mental evaluation and radically shorten your time, but you could still be there for a month.
right.
You know what I'm saying?
Right.
Because the U.S. Marshals are kind of slow about getting you moved.
One of 4 IQ, what can you expect? Facts put into evidence by testimony. It is my understanding that evidence is in order to be admissible, would have to have relevance.
Right.
Okay, so to your statement where you say you have to have facts put into evidence by testimony, can we add relevant evidence? Because they'll say a bunch of crap.
Oh, yeah,
Let's take
it's
an
gotta
IRS
be-
case. They're going to have 15 IRS witnesses, and they'll state the facts. And what I'm noticing is that they state the facts of what they did, but neither one of them can state to the truthfulness of the numbers in the documents they reference. They come from some computer, somebody else entered it
Okay,
from this office, that
On
office.
those tax cases, they'll never have the paperwork done right. They'll never have a lawful assessment. There's several points that they have to meet in order to have it be a lawful assessment. But they'll come into court and they'll say, well, we got this computation and we got such and such records. Well, U.S. versus Smith, you can refuse to allow them to bring in business records. Most people don't know that.
The judge does allow that though.
Well, this is a case that says, no, they're not allowed.
Right.
And now, if you run into that situation, it's just like Don McCarley. He was denied assistance of counsel when the United States Supreme Court said, you can't do that. Yes, he was denied assistance of counsel, So he walks out the front door of the courthouse. You know, see, it sets up a heads we win, tails they lose situation. You've got it, what they have to do, what's right to do, what's lawful, and then when they break the law, well, they lose the case. So if they did what they're supposed to, they lose the case. And if they do what they're not supposed to, they lose the case.
It's our experience that in tax cases, what they do, the judge will allow the jury to see inadmissible evidence, and in the end, he'll advise the jury that this is the law, and the law says these guys have to pay, and you signed an agreement that you're going to take the law as I give it to you, and I'm telling you that the law says they have to pay, and that's about it. And he's the dictator at that stage of the game, and the jury convicts. And they don't seem to care that that's the issue, because now the world knows these guys went to jail, and 6 months later, they win on appeal, but nobody knows that. On reversible errors, like you're suggesting, I'm assuming you're keeping out their evidence, or you're triggering the mechanism for reversible errors. Am I correct?
Right.
Very well. You mentioned the DWI case. I know why your clients got off. Would you like me to tell you? There were no celebrities. Okay. Now,
That's a good one, that's a good one.
Say that again, I don't hear.
there were no celebrities. Obviously, they need a celebrity to make a case carry the rest of us, right? So there's your answer. Okay, joking aside. You mentioned going to the grand jury. That we find that that's not an easy task, and they'll block you. And if you try to go to the grand jury when you're in a particular case, they'll attack you as tampering with the jury. Have you tried that many times? Do you know of a path that's easier because the prosecution will disallow it and they'll jump all over you?
Well, as a matter of fact, that's what I was planning on discussing tomorrow.
Good.
When we go
Enough said.
from the issue of indictment, arraignment, pretrial, trial, and sentencing.
Okay, thank you. Then you went on to affidavits, but in every case you've only referenced affidavits filed in the state courts. Would it be the same thing with a federal, or where would you file with a federal affidavit? In the particular court you're in, or?
Okay, when I was talking about Dr. Barry Brooks, that was federal.
Oh, it was federal.
Yeah, and I got another one here that I could share with you about a guy by the name of Jeff Skiba.
Sure. All those documents be available for everybody with copies, if we make copies? Or not
Well, we're
necessarily?
going to have to send out to get them, some of them made tomorrow, maybe, or I can. I've got a bunch of this stuff on an e-disc,
Great.
but we didn't have a duplicator here. I've got back in Texas, 1 in and 7 out, and but I was like swamped and I didn't have a chance to create the disc.
Okay.
So
Can we make that available with the DVDs?
Yeah,
If one of us offers to make a copy, just throw it
I
out.
was gonna send that with the DVDs.
Great.
The what was it again? What were you asking?
What was your question? Not important, they got it. It's on tape.
Filing those
By the table,
Filing
okay?
those affidavits into the court,
Yes.
in federal court.
Right.
Oh, yeah. Well, in the Skiba case, I filed one document, the case was finished. And
The affidavit.
that was,
The affidavit. You filed the affidavit. We're talking about affidavit in federal
yeah.
court.
I've got a copy of it right here.
Great. In an IRS situation, this affidavit, can you kind of sketch what would go in there in that affidavit in an IRS case? Are you going to address that tomorrow? Do you have a case with IRS that such an affidavit was filed into a court and had this effect, or is not the case, does not apply, or can you elaborate on that?
Well, these cases may have some things different, but then there's some areas of commonality as well. Like Tim and Dawn's case, that's a tax case. But it's not like every tax case. That's where they denied me as being a witness.
Understood.
The judge denied.
That's why I'm looking at the affidavit, because the affidavit in a tax case would be pretty much the same issue, cookie cutter, I would assume. Facts are different, there's circumstances, but whether there's a liability, duty, et cetera, in tax, the affidavit would more or less be in the same vein.
On that, I have a little bit different approach than a lot of people.
Great.
I put together a page of questions for Tim, and, he didn't ask the IRS agent this stuff because it's too ferocious.
You gotta be ferocious, those guys are monsters.
And, I'm debating in my own mind whether we should even have that on recorded, because I'd rather almost that we just turn the recorders, all of them off, and I explain to you how to win those deals.
Show of hands, everybody okay with that?
Yeah, come on.
We're
Let's
cool.
do it.
Yeah, we'll do that. We'll reserve, how much do you need? 10 minutes, 15 minutes, half hour?
Yeah, something like that.
Okay. On what basis did you fire the attorneys in the Isabella's case, or Isabella's, whatever?
Well, that was Zoila.
Zoila.
Isabella Suarez was the one who was denied her medication. I just had it crossed in my mind. She was denied her medication at that federal facility, and the paramedics came and they wouldn't let him in, and she died and all that stuff. But the one in Chicago
Zoila.
was Zoila.
That's the one I'm talking about. What was the basis for you firing the attorneys in her case?
Incompetence.
She didn't do anything, he didn't do anything.
Yeah, he didn't look at her evidence. He didn't subpoena her witnesses.
Okay, so those are technical, that's what I was asking, particulars. So this number one, number two, number three, so there were several elements that he didn't do his job.
And, once you discover that they have no ability, or they're not going to exercise any due diligence for your case,
Right.
what do you need them for?
Yeah, well, the reason I'm asking is because we have a similar case in Northern California. There was a list of 139 questions asked, and they couldn't answer these questions. And the federal judge specifically said, well, look, we have these public attorneys here, and they're very competent.
Yeah.
And if you can't find, and they recommended Larry B. Kraft. The court recommended Larry B. Kraft as a tax attorney, and we found that quite intriguing. But
I'm sure all the other people that are in prison would also find that intriguing.
Yeah, well,
that's the ones that paid Larry.
Yeah, just for a quick comment, if I may, please. It really serves nobody for us to bash each other or to speak negatively of each other. I think the time is for all of us to kind of pull them together. And if we show a little bit more understanding of the attorneys, maybe they'll try to understand a little more of where we're coming from.
That's like training scorpions, right?
I refrain from that. I think we need to harmonize. I so happen to know they do have they have good intentions, and whether they're misguided by previous education or not may not make a difference. Okay. All right.
Deep down, they're really good. That's why they bury them 12 feet instead of 6.
All right. There was another question, but it was not going to be placed by me. I have a young man who wants to say. All right, Jesse. Thank you.
On a couple of those cases you talked about allocution, when those people walked out at their allocution, did the felony stand against them? And if so, is there a way to get rid of that?
That's a good question, and I am not sure.
Yes or
I
no?
think it probably dropped off, but I don't know for sure. You know, one of them, I coached a guy over the phone, for instance, Reverend Austin Miles in California. Apparently a lot of people know him. And, you know, he called me. He'd already been convicted. And his sentencing was coming up. And I coached him. He walked out the front door. As to whatever happened after that, I'm not sure. And I did get a letter from him, you know, declaring that, you know, that I coached him and helped him understand this thing, and that he was able to walk out the front door. Don McCarley walked out the front door as well. Now, I was involved in Don's thing from close to the beginning, but a lot of times the people will call me and they're already through a whole bunch of it, like Austin Miles was. It's already convicted before he made contact with me. And I've had a lot of cases where I'm only involved in a piece of it. And, you know, I don't know, I can't remember all of the stuff that I've been involved in, but some of the things are pretty amazing, like they were with Zoila. I'll never forget that one, you know. And there's another one, I mentioned Jeff Skiba. How are we doing time-wise? What are we doing on this?
We started a new tape, so.
20 after, and,
You ran out of time.
We're overtime.
20 after, so if you want to take a few more questions, you can, or you can, whatever.
If you're hungry, we'll bring you a cookie.
Yeah, about 10 minutes and be 5:30.
I have 5 questions. I'm probably going to ask one.
Mic on.
Switch on.
Upwards. There you
I read a lot on the attorney's notice of appearance, and you mentioned the attorneys do have to make an entrance into the case. What exactly is the notice of appearance? Does it represent some kind of a trust, an insurance policy, some kind of bond? Do you know?
Good question. I don't know the
I know,
answer
I
to
just
that.
think there's more to it. And someone actually a few years ago did say and gave me a huge explanation that at the time I didn't understand. But I just want to get to the bottom of what exactly the notice of appearance actually is, because I think there's a lot more to it than just an attorney saying, hey, I'm here.
You may very well be right. And, you know, I just don't know the answer to that
Does
one.
anybody know or know anybody that I can talk to that would know?
I've heard that. I had a case dealing with that recently, and I was asking the attorney themselves, because I was interviewing attorneys for competence, and I asked them if they knew what the difference was between representative counsel and the assistance of counsel, because I was not interested in representative counsel. I was not interested in becoming a ward of the court, and I was not interested in retaining their services. I was interested in possibly hiring them to assist me, that they knew the procedure. And this was something that I had learned from somebody. So I was just questioning him, asking that. So I don't know if the notice of appearance is a notice of representation, and letting them know that you are waiving certain rights, the right to speak, the right to talk to the judge. I don't know. That's just what my idea of it is. So I don't know if that helps.
A few years ago, it seems like they said something about that it goes into, it has to do with the trust and their bonding and all of that, but it was a big deal. And it's not something that you're just going to read in the rules of procedure or something. Anyway, I just thought maybe somebody might know.
Yeah, I wish I knew everything, but I don't.
Okay. And then you had mentioned earlier 5 types of affidavits, if you could talk about that.
5 types of affidavits?
Yeah.
There's 5 elements.
Oh, it's 5 elements? Okay.
Yeah, we need to know that.
That's the same thing.
He gave 4.
And then in the beginning, and I missed this, you mentioned Rule 12.
Yeah.
Was the federal Texas.
Okay, it was Texas Rule 12, and that's just, you challenge the attorney. What Texas Rule 12 says,
Is it rules of
is
civil procedure? criminal
civil,
procedure?
yes.
Okay, that's all. That's what I wondered.
Okay.
Thanks.
But it's civil procedure, but you can use it anywhere because the concept agency is what is over everything.
I meant to mention this before, with agency, if anybody's studying it, you might also want to research public policy because that's where they're going to get you. That makes sense.
You didn't turn it on.
Yes, it is turned on.
It is turned on.
During Sue's case, we discovered that if an attorney does not enter himself into the case properly, he has no right to speak at any time during the proceedings, period. And if you discover in your case, and you search your records, that attorney has not entered properly into your case and gave notice to the court that he has entered into the case, he has no standing in that court whatsoever. He cannot speak in that court. He don't belong in there, out the door.
He's trespassing. And everything he enters into the case
Is out the door.
stricken.
Has to be stricken.
So is that a document that he might have to enter into the case?
Notice of appearance.
It'll be right there on the United States versus you, and it'll be right on there. And his bar license number and everything will be there. And if you go back into the docket, there will be a place in the docket where he entered the case. If it ain't there, it notices the court that he's in the case as an attorney. And if he ain't there, he's not properly licensed, his bar license ain't there, he can't belong there. The federal court, they all in her case, speak the devil, they all in her case said, oh, excuse me, I'm working under my boss's license. Well, guess who her boss's attorneys were? The guy who just got filed criminal charges against got fired.
Fast and
Mr.
Furious.
Dennis Burke.
Under the Fast and Furious scam.
The Fast and Furious scam. He's the one who stole $100,000 bail money from me that I bailed her out of jail with, and we're going to file charges against Dennis Burke and the court that he used that $100,000 to give to those drug lords down there to shoot that cop.
By guns.
Yeah, he used that money to buy guns with that he stole from me.
This is
They got to prove otherwise.
This is off the tape, I hope.
It's only me editing. Don't worry, it's only me editing. You talk to the editor right here. Now we get a charge, huh? This is how we make the buck.
Talking about the attorneys having to file an appearance, I did have a case in which the attorneys did not. I did file a motion in the court stating it such. And obviously, not knowing exactly how things should be done, we're finding ourselves in a situation that even if you do it right, or if you don't do it right, they still want to move forward. And I think that's one of the things I'm really hoping to find here is trying to get enforcement, trying to get some power, trying to get some authority. And that's why I really think that the agency is a very important part. Again, trying to get followed through, I think, is one of the problems I'm experiencing, and it sounds like some others are maybe here too.
What was your question?
I said more of a comment. What was the question?
Oh,
In a case I'm involved in, there's an attorney says that she is the bank's attorney, and her name shows on the documentation where she files. But I went into the records and went pulled all the records, got certified copies, and nowhere in there could I find anything that said she represented the bank, that the bank gave her authority to represent him. So, is she the attorney of record, or is she just BS-less?
Well, I can't tell from here whether she's the attorney or just BSing you. However, I think you'll be surprised to know, and we're going to run this by you. When the attorney says she represents the bank, and you make the challenge, And she comes back and she said, well, I got a letter here from the bank. Excuse me, any high school kid can create a letter from the bank. Get the picture? What you can do with computers these days is astounding, okay? So, yeah, Obama's birth certificate, thank you. So anyway, the attorney says, well, I got this letter here from the bank. That's worthless, that's not evidence. So then the attorney says, well, I got this check and I got this affidavit. Well, all affidavits, if you're in court, okay? And it's the showdown time as to where's the evidence, okay? And she says, well, I got this affidavit here. Well, all affidavits are hearsay until they're testified to. So it doesn't matter who signed the affidavit. If they're not in the courtroom to testify to it, it's hearsay. Next, what do you have? And so then, if by chance, she says, well, I got somebody here from the bank. Okay. Well, if it turns out to be that they dressed up the janitor to put out on the witness stand, that's not going to work if you ask the right questions. Now, supposing it's somebody serious, a vice president or a CEO or something like this, and they get on the witness stand. First thing they have to do is prove who they are. Then they have to, this is one of the beauties, because I took training from over 50 top trainers, and John Nelson was amongst them. And John Nelson is off the scale. Comparing others with John Nelson is like comparing Cessnas with the Starship Enterprise. And I was tutored by John Nelson, and so anyway, when they raised this, that they have the authority from the bank, etc., because they got this guy on the witness stand, there's a case that John Nelson turned me on to, and it's called Osborne versus U.S. Bank. And this is an 1824 case. It's approximately 100 pages long. And it has a lot of stuff in it. For instance, all attorneys know that corporations must be represented by an attorney. But if you ask them where they came from, they don't know. Well, that's the case where it comes from. The case has been cited thousands of times and never overturned. And it's, like I say, it's from 1824. Now, what that case says is it addresses the issue and says that their whole authority derives from the charter. And the charter is the law for the corporation, which is the bank. And if they're going to show up in court, they have to have the law in their hand. So if they don't have the corporate charter in their hand, they got nothing. And furthermore, the CEO who's on the witness stand has to not only have the corporate charter, but he also has to have the minutes of the meeting where he was delegated the authority to hire the attorney, and without all of that, he can't point to the attorney and say, and that's the attorney I hired with full authority. Now, you can see the kind of complications they have, because they come in, they're arrogant, they're lazy, and they're stupid. So when they come in, they don't come in prepared. And it's like the attorney in Dallas about the house and Bankers Trust of California. And I went like this, and there's nobody in this courtroom from Bankers Trust of California to verify what this guy is saying, and he lost the case right there. It took 10 days to get the certified win in hand, but that's what it was.
That's huge. That is huge. What's the other Osborne versus who?
U.S. Bank.
US Bank?
U.S. Bank or Bank of the United States, I forget which. 1824. Well, it appears I'm wearing out some people's ears.
Yeah, we need a break.
Yeah.
No, those are the considerate people. We want to stay.
Look, you'd have to talk to Ron and Susie about staying the night here in this room.
Everything is negotiable, right?
Everything's negotiable.
I want to hear about the IRS. Can we turn the recorders off and do that?
Well, those other people left.
How about tomorrow? I think we have a lot of people that have flown in and they're tired and, get some rest.
Are you staying tonight? Because then we can do it the first thing tomorrow morning, if you're staying tonight. If you're planning on leaving,
He just lives down the street.
you got no excuse then.
All right, then. I guess we'll see everybody tomorrow at 9 o'clock.
Great, all right.